Hello and welcome to the Herrington Carmichael Employment Law Update for November 2016. I'm Alistair MacArthur, I'm the head of the employment team here at Herrington Carmichael. As we move into November, it may be getting colder, but I've still got 4 very key, important employment cases to bring you this month. So where do we start? We start with the issue of shared parental leave, and in particular the case of Snell versus Network Rail. What we have here is we have a situation where both a father and a mother are taking shared parental leave. And Network Rail gave the mother enhanced maternity pay, but didn't give the same to the father. What happened was the father pursued a discrimination claim on the basis of his sex, and unsurprisingly, he won. What do you need to do? Go and look at your parental leave and shared parental leave and maternity policies, and just make sure that if you're paying benefits under those schemes, that those are equal to both the husband or partner and the mother of the child. Make sure everything is equal there and the right amounts are being paid to both parties. In this case though, it did encourage Network Rail to reduce the benefits being paid to mothers who take maternity leave, so therefore it didn't actually necessarily benefit everybody. Next, equal pay in the case of Briley versus Asda. This has been in the mainstream media and has got a lot of attention because it's a potential claim involving 7,000 Asda workers based in their stores who are comparing themselves to workers in their delivery centres. The predominant female population in the stores are saying we should be paid the same as the predominant male population in the delivery centres. Now this case, although it's got a lot of press coverage, is only at the preliminary stage, and the tribunal has said that the workers can compare themselves in the 2 different centres. It's one to watch closely. It's nothing of any great differences in the law, but what it will show is whether the Asda can actually justify the differences in their pay. Next, workplace privacy issues. In the case of Brown versus the Commissioner for the Police of the Metropolitan and Chief Constable of Greater Manchester, we have a case involving Mrs. Brown who goes through a disciplinary process. Greater Manchester Police go off and try and gather a whole array of irrelevant information such as flight details and information about Mrs. Brown's daughter. Not appropriate, breach of data protection, and Mrs. Brown won £9,000. What's important to you? Make sure if you're conducting a disciplinary process, you're only accessing information which is of relevance and are not going hunting for information which is of no issue or concern to the facts of the case you're dealing with. Keep it simple. Deal with the issues in front of you. Don't go looking for anything new. Lastly, the case of Lee versus Ash's Baking Company. This is in Northern Ireland. This is colloquially known as the gay cake case and involves the bakery company who refused to bake a cake supporting homosexual marriage. What the case effectively says is that that company couldn't impose its own views in this situation. It's not a case where they were performing a function which was related to their religion. It was instead performing a function in relation to baking cakes. It doesn't say they're endorsing gay marriage, and therefore they should have undertaken the baking of that cake, and by not doing so they were discriminating against those individuals on grounds of their sexual orientation. What do you need to do? Be careful with your activities. Make sure you treat everybody equal and do things which are in accordance with the Equality Act. That's it from me this month. We'll be back for a very special Christmas version in December. Thank you.